Good afternoon, everyone. My name is Dorian Persaud. I am your host for the webinar this afternoon. We're just going to give folks a couple minutes to register and sign in, and we will get started shortly. Good afternoon, everyone. My name is Dorian Persaud. I am the senior partner at Persaud Employment Law. We are a team of lawyers that specialize in conducting workplace investigations and helping you to create healthy workplaces through investigations, training, and proactive advice. I want to offer a special welcome to those of you who are joining us for the first time. We look forward to your participation today, and we would invite you to join us for future events. This Ask the Investigator is a series of webinars that we host each month, and we would ask that you consider attending next month's event that will occur on June 29th, and we'll be looking at the issue of confidentiality and how do you respond when a party to an investigation or their representative wants to record the investigation interview. What implications does that have in terms of the integrity of the investigation and any legal liability that might flow from that recording being published? So please join us next month on Thursday, June 29th at 12:30 to 1:30 in the afternoon. As we unpack that event for you. But today we're looking at the issue of sexual harassment investigations and the unique problems that these investigations present. And certainly as we've seen the return to work and with folks spending more time together with schools, back with having in-person learning, as the world gets back to normal, we have seen an increase in these cases of sexual harassment. So we want to make sure that you have some guidance as you approach these complex investigations. And one of the questions that we're often asked at the beginning of this type of an investigation is, by the employer, they want to know, hey, Dorian, should we even be involved in this? Because it might be a serious situation where the police are conducting an investigation. And so the thought process for the employer is, well, shouldn't we just, sit back, let the police do their investigation, and we'll piggyback on that or take whatever steps are necessary after that criminal investigation is done. And the way that you need to approach this as an employer is to understand that in these complex scenarios where a very traumatic event and serious event has occurred, you're going to have different layers of investigations that may be happening all at the same time. But each of these different bodies is approaching the investigation in a different way. So what you as the employer want to do is just to be very clear in terms of what your obligations are and what you need to do in order to create and maintain a safe work environment. So you're going to go back to your statutory obligations, and there is legislation. There's also case law that mandates that when an employer is faced with a serious complaint, that the employer conduct an independent investigation to take that complaint seriously, look into whether or not any of these allegations occurred, and take the appropriate steps in response. So that's your obligation as an employer, is to maintain a workplace that's free of violence and harassment. And the way that you do that is by conducting an investigation when you are faced with these complaints. Now, with respect to any criminal investigations that might be occurring, either at the same time or during the course of your investigation, you want to keep in mind that The police are approaching their work through a different lens than you are. So you as the employer, you're looking at this work through, as I said, your statutory and your common law obligations to provide a safe workplace. What you're trying to figure out is, on a balance of probabilities, is it more likely or not that these things that are complained of happened? And if so, what do we, as an organization, need to do in response? The police are looking at this through a very different lens, which is the criminal law lens. And has there been a violation of the criminal code? Is the behavior complained of, does that rise to the level of sexual assault? Will a prosecutor be able to take these charges and prove this charge beyond a reasonable doubt? So when the police are doing their investigation, they're approaching it from that perspective. They're taking that evidence that they collect and they're handing it over to a prosecutor to then determine, is there enough here for us to lay charges and move ahead with this case? So you can see that it's a very different perspective that they come to this with. In addition to that, you might also have a regulatory body who is looking at issues of professional negligence, right? You see this, especially if there's someone like a teacher that might be involved, or a professor that's involved in the sexual harassment complaint. So they want to look from a professional code of conduct perspective, has this person fallen short of the standard expected of them? Should they have their license suspended or taken away? So you have these very different perspectives taken by each of these different bodies, but each of them have a unique role to play in the same set of circumstances that they're all wrestling with. Each one is tackling it from a different point of view. So you as the employer, you never want to defer to this other party and sit back and not be proactive and do your own investigation. Because just because the police reach one conclusion, that doesn't mean that you as the employer, again, on that lower evidentiary standard, on a balance of probabilities, it doesn't mean that that there wasn't misconduct here that you need to address in the workplace. I forgot to mention at the outset that we are, as you know, going to save a lot of time for questions and answers at the end of this presentation. So please do use the chat function and direct your question to everyone. And my colleague Leila is on this webinar with me, and Leila will feed me the questions at the end of today's session. So the presentation should last about 20 to 30 minutes, and we'll have another 30 minutes for Q&A. When you are faced with a sexual harassment complaint, there are a lot of things that are going through your mind. You're thinking about how quickly do we need to respond, and who's going to investigate this, and are the police involved? And in the midst of all of that chaos, it can seem overwhelming in terms of how do we set up this process? What is the next step that we make? And we always advise our clients to take a step back and focus on that process. You want to, at the end of the day, what you want to do is put together an investigation framework and a process that's going to stand up to scrutiny. And you want to make sure that that the basic elements of fundamental justice are honored. And so we've laid that out for you. At the end of the day, you want to put in place a process where both parties have a right to be heard by someone who is impartial. And so that can be someone internal. Oftentimes, and depending on the severity of the allegations, it will be a third party investigator. But the important piece here is that whether internal or third party, you have an impartial person judging the circumstance. You want to make sure that the responding party is notified of the allegations against them. You don't want to conduct an investigation by ambush. So they have a right to know, look, here are the things that you are accused of doing. These things occurred on such and such a date. You want to provide them with enough information so that they can attend an investigation interview and be able to respond to these allegations that have been made. That means giving them adequate time to go through their text messages and go through their emails and prepare for that interview. Many of the sexual harassment investigations that we've been involved in, some of them are the result of recent events. Many of them span years before an individual comes forward and files a complaint. And so, given that these events may have been spread over a number of months or even a number of years, you want to give that person adequate time, right, to go through and gather the information that they need to in order to answer the difficult questions that they are going to be asked at that interview. You want to, similar to choosing an investigator who's not biased and who's coming at this in an impartial and neutral way, you want to make sure that the person who is making a decision after collecting this evidence, that is the person who heard the evidence, right? What you don't want is someone going off and doing these interviews, collecting that information, and you have another person who's just reviewing the notes and making a conclusion based on not having experienced that evidence firsthand and just looking over somebody else's work, right? So you want to make sure that you have one person who's or a team of people who are in charge of conducting these interviews, reviewing the evidence, and then making a decision on making a finding and then determining what needs to happen next. In these situations, when we're dealing with a sexual harassment, we can all appreciate that that victims, suffer, long-term and very damaging effects. This is, by definition, just a traumatic event for the individual, and we often hear that in approaching this work that you should believe the victim, and what we advocate for is showing compassion to the victim. But as an investigator, when you're approaching this, you want to put in place a framework and a process that will stand up to scrutiny, and you want to let the evidence guide you. So you're not believing the respondent or the complainant. You are showing compassion to both sides, and recognizing that what this person allegedly experienced is very serious, but you're at all times, maintaining that impartiality and being guided by the evidence. And there has to be that recognition there, right? That in this process, there is a responding party who may, at the end of this, be falsely accused of sexual harassment, and that has a significant, damaging. It can be, very damaging to their reputation and their ability to work in that specific workplace, or maybe in the industry going forward. So you want to be mindful of the potential impact here and the very damaging effects that this can have on the responding party as well. And again, approach the work with compassion for both sides, and approach that work in an impartial way with a view of getting at the truth and finding out what actually happened here. I find sexual harassment complaints are a great opportunity for employers to really learn about the culture of their workplace, and you are able to determine that in a way through how comfortable people feel coming forward with these complaints, right? Like, are you seeing these behaviors being swept under the rug and building up into much more serious situations where people feel like maybe their complaints are not going to be taken seriously, and so they wait 2 years before they come forward, and now they're dealing with, and you as the employer are now dealing with a much more complex situation. It gives you that opportunity to unpack what was going on there in that intervening time, where someone was experiencing something problematic but hadn't come forward, because you don't need necessarily a flagrant act of sexual assault for someone to feel that they can come forward and report that. Just these smaller incidents, but occurring frequently, can have a very damaging effect on the individual and on others in the workplace. So these investigations give you the ability to get that insight into what was happening in your workplace, so that you can look at addressing that cultural issue going forward. In terms of what sexual harassment is, I think we have a good understanding of that. It can be comments on a person's appearance, on their clothing. It may be demands or threats that's made of someone. Obviously, touching an individual would be sexual. It can be sexual harassment, and in there looking at where you're touching and the context around that, obviously, but then you also have sexual communications, via emails and texts, and suggestive comments that are being made. And so oftentimes it isn't one thing; it's you've got a series of things that are going on here. But at the end of the day, it's should the responding party known or ought to have known that these behaviors are unwelcomed, and so you're looking at all of these behaviors in context. You also have, we talked about sexual assault, which is touching another person without their consent, and that contact is of a sexual nature. And in analyzing these complaints, and as approaching the investigation, it's really important to understand the power imbalance that often exists in these situations. And so you quite often, not always, but you quite often have someone who might be in a position of power, right, and influence, and that person might be able to withhold a benefit or withhold an opportunity from the victim. Sometimes that power that they have, sometimes it's actual, right? They actually do have that authority and that ability to open doors and close doors. Sometimes it's perceived. We conducted an investigation for a college where the students and faculty who came forward, they perceived that that this professor kind of was a gateway to jobs in the private sector, and therefore upsetting this professor might lead to them not being able to pursue gainful employment after their program. And for the most part, that was perceived, that there were many avenues into the private sector, that they did not need an endorsement from this particular professor. But just over time, you have someone who builds up a reputation, and students coming into the school learn of that, maybe the reputation or the weight that this professor carries at the school and in the industry. And so sometimes, as I said, it isn't real influence. It is this may not be their actual influence and reputation in the industry per se, but because the faculty might perceive that to them it's the same thing. And so that explains then how they might get into these situations, and why it might is difficult for them to then come forward early on when they're experiencing problematic behaviors. We also often find that in these situations, the folks who are affected are vulnerable, right? And so you have these different, intersecting issues and characteristics to consider. Sometimes these folks come from a troubled home and experienced, trauma, in a domestic relationship. They might be suffering with an addiction of some sort. But those are things to look out for. Are there certain vulnerabilities there, or other intersecting grounds that make this individual more susceptible, and explain how these events unfolded. One of the biggest mistakes that we see employers make when setting up these investigations is not appointing or assigning the investigation to an impartial person. And so there's cases of sexual harassment or assault in the workplace where the employer has gone with someone in-house, but someone in-house who is familiar with the responding party and maybe friends with them. One of the most significant cases in the workplace investigation case law is a case involving Bell Mobility, where they had a a manager who shoved one of his subordinates, a salesperson who reported to him, shoved her into a cabinet. There was months of escalation before that, but he lost his cool one day, shoved her into a cabinet. She never returned to work. And Bell Mobility, in terms of conducting that internal investigation, appointed an individual in HR who was, as I worked for a long time with that responding party, and did not conduct a proper investigation. In conducting the investigation, didn't actually even meet with the complainant because he just thought by reading her written complaint that was enough. It was detailed enough. He didn't have to meet with her to actually better understand her story. But spent a lot of time meeting with the responding party and unpacking his concerns and his response. And so that's one example of where it's just so important to appoint someone who's not just competent, but you want to make sure that they're neutral as well. And someone who's got a long-standing relationship with either of the parties is not going to be perceived as neutral, even if they do their job well and they conduct a proper investigation. Again, what you're trying to do as the employer is to set up a process that's going to be free of bias or perceived bias. And so having the investigator be on friendly terms with any of the parties is a problem. Specifically when it comes to sexual harassment, you want to have someone who has some experience dealing with sexual harassment complaints. There's a well-reported decision involving Home Hardware where they were dealing with a sexual harassment complaint out of their a location in Alberta. They sent an investigator from head office to investigate that. This person had conducted many investigations before, but had never conducted a sexual harassment investigation, and really dropped the ball in terms of how he approached the work, how he conducted the interviews, and the conclusions that he ultimately arrived at. So again, this is one of the first things that you're going to be deciding when you're faced with these types of complaint, and you want to make sure that you choose an investigator who's competent, who has some experience with sexual harassment complaints, and who's going to be able to do the work and do it in a way where, at the end of the process, folks will look at that and not have concerns that the process was flawed or biased in some way. As you're going about this work, confidentiality is key, and especially given the sensitive nature, right, of the evidence that's going to be collected in a sexual harassment complaint. And one of the concerns that we've seen in a number of cases now is where there's a union involved. Oftentimes employers will have a policy and will have a practice in place to deal with confidentiality. However, we often don't think about the union rep that might be acting as a support person to one or both of the parties. And what do you do in the case where the union isn't respecting those boundaries when it comes to confidentiality? And we had one case in particular where you had a union rep representing a responding party to a complaint, and in the midst of that investigation, a separate complaint was filed against the same responding party. And what this union rep wanted to do is take not just the notes that that they were recording during the interviews with the responding party. They wanted to take they went to their colleague and asked their colleague to share notes with them as well, and say, look, can you give me your notes? And so that we can kind of put these things together and essentially create a defense for this person in this subsequent investigation that's been filed. So taking the evidence and the notes from one investigation, investigation A, and using that to defend this respondent in investigation B. These are things that are happening, but in fairness, are not on our radar because we don't really turn our minds to that event. We think everyone is just going to respect issues of confidentiality, but we can see that that's not the case. And so, insofar as employers need to have robust policies and practices when it comes to maintaining confidentiality during an investigation. For those of you who are working in a unionized environment, you want to make sure that the unions that you're working with also understand this, and you want to find out what steps they are taking to preserve confidentiality, where they're acting as a support in a support role to individuals and witnesses that are involved in a workplace investigation. I want to spend a little bit of time on, unpacking the issue of taking a trauma-informed approach to your investigation interviews. I want to spend some time on that issue before we move to the Q&A. And we have a definition here from the Center of Addiction and Mental Health. Trauma is a lasting and an emotional response that often results from living through a distressing event. And that's what we're dealing with in sexual harassment complaints is, oftentimes this is a very troubling and a distressing event from the perspective of the complainant, and that trauma will then manifest itself in different ways. And we as investigators and you as employers need to be cognizant of those symptoms of trauma, so that you can conduct investigations in a compassionate and an effective way. Now, one of the things that you want to understand is that is how that trauma has affected the complainant, and that's going to inform your approach to how you conduct the interview and how you interpret the evidence. So trauma can affect your memory, and can result in mental or physical disability. But when it comes to memory, you may not remember all of the details of what you went through, because because of the trauma, you've tried to repress these details and block them out to some extent. You may not be able to recall the details in chronological order, the way that we would normally hear a story told, right? So somebody complains about being bullied in the workplace, they'll tell you the story. Here's when it started. It was after Labor Day weekend, and they'll take you through from Labor Day weekend all the way through Christmas, and then the culminating event, and in February or around Valentine's of the following year, right? They kind of walk you through in chronological order. In an investigation where someone is suffering from trauma, they don't necessarily do that. They are telling the story in their own way, and that varies, based on the individual. But there's a lot more jumping around, and so it creates more work for you as the investigator to listen to that story and not force that story out of them. So you're not forcing them to tell their story in a rigid chronological way. You are listening and letting them tell their story. You're taking notes, and you're then having to do the work of going back and filling in those gaps that exist. So you're not approaching this with any less rigor, right? It's not to say that because you've been traumatized, you get a free pass in terms of what you remember and in terms of the questions you're being asked, and maybe certain points that you might be challenged on. However, you're taking that compassionate approach. You're understanding the trauma, and you, as the investigator, are adjusting your approach accordingly. You want to make sure that you're making this as predictable a process as possible, right? So one of the things that cause stress to someone who has been traumatized and who is then facing the additional trauma or difficulty of having to tell their story again and relive these events is confusion about what is the process that's about to unfold. And so you want to make that as predictable as possible. You want to give them, advance notice of, where you're going to meet and what that meeting is going to look like, and what are the different steps in the investigation. And after you meet with them, where does the investigation go from there? Confirming that you are going to put these allegations to the responding party, letting them know that you'll need to maybe come back and have another conversation with them based on what you learned. So just spelling out what's going to happen. And then at the end of the investigation, the fact that the employer gets a report and the employer takes the appropriate steps at their discretion in response to that report. So just making all of that clear puts the person at ease when they're coming forward, and as they're feeling anxious about their participation in this event. Taking that sympathetic approach, you want to also be mindful of how you pace yourself during that interview, right? Someone might be taking breaks because it's exhausting, or they're taking breaks because they're crying, and that takes energy, and so the whole thing takes a lot of mental and physical and emotional energy. And so when you realize that you are not trying to squeeze all of the information out of this complainant at the initial interview, or conducting an 8-hour interview to get this information, you're pacing yourself, and you might have to break the interview up into smaller chunks. You want to, I mentioned, making sure that the person can tell their story in their own way, so they don't have to tell their story in a linear way. You're going to still conduct your work with rigor, so you can have follow-up questions in response to something that someone may have said, or something that they may have skipped over, but you want to ask your questions, in a way where, I think, in a different context, it wouldn't seem accusatory, but especially in the context of someone who's the victim of trauma, the way that you frame your questions, takes on greater importance. And so, simple things like, framing your question is, how did you respond, when such and such happened, in contrast with, well, did you do this, when so and so acted this way, right? And so it's a very subtle difference, but to the person on the receiving end of it, it makes a huge difference to them in terms of feeling like they're being listened to, as opposed to feeling that they're being attacked or judged for not having done something. And it's not to say that you can't make those conclusions at the end of the day, but in terms of approaching the interview and your approach to the witness, you want to be very mindful of your words and how those are going to be interpreted by the person across the table or across the screen from you. We talked at the outset about just making sure that we approach this work in a fair way. So you're not coming into this work saying, I believe the victim, right? You're coming into this work saying, I'm going to show compassion to the victim. I'm going to show compassion to the responding party. And I am going to approach this work with an open mind, with a view to letting the evidence lead me. So we're not prejudging anything. We are at all times being guided by the evidence, and letting that inform the conclusions that we make. A lot of sexual harassment investigations, turn on other evidence, right? So you've got the evidence of the parties that you get through the interviews, and then you have, emails and text messages that are that might be entered into evidence, and that fills out the relationship between the parties and helps you to better understand what transpired. So you want to make sure that you have the capabilities, whether in-house or through a third party, to access social media platforms and to recover lost text messages, and to be able to capture all of the relevant evidence in the investigation. One of the issues that we often see is folks making a decision in terms of credibility, right? Because in the vast majority of cases, these cases do turn on credibility. And sometimes we see a credibility assessment being made based on demeanor of the witness and how confidently somebody spoke, and their body language. And just want to caution against that. And so it's not to say that you cannot rely on these things, because they are very important cues. Oftentimes, in terms of whether someone's telling the truth, you definitely want to pick up on how comfortable somebody is when they're giving you evidence on a topic that they're comfortable with, and then on a more difficult area, how do they change? What is that change? In terms of how they deliver their evidence, is it eye contact? Is it they just can't remember all the difficult, their evidence on all of the difficult points? What is it? Are they fidgeting? Do they become more aggressive? You want to pick up on these cues, but you want to hang your hat when it comes to making a credibility assessment. These are, these things like body language and these other cues are, things that would round out your analysis maybe of someone, but you want to hang your hat on something that's solid. So you want to make sure that that you're collecting the evidence so that you can rest your credibility assessment on the on the documents that you received, on the evidence and the corroboration that you received between one person's evidence and other witnesses that you may have interviewed, or that evidence and the documentary evidence that you collected. Maybe there's more consistency there. So at the end of the day, when it comes to credibility, what you're looking at is a story that makes sense, right? So you're not looking at who spoke the best, or who seemed persuasive, who appeared to be most confident. You are focused on, am I being told a story that makes sense after I consider all of the evidence? What is the reasonable conclusion that I'm left with here? At the end of the process, you're going to report back to the parties in terms of your findings. If there's a finding against the responding party, then you'll want to also turn your mind to what are the consequences for that violation of the policy, and even if the allegations aren't founded, you still want to look at, was there, problematic behavior here that maybe didn't rise to the level of a policy violation, but still is something that we want to, address going forward. Similarly, if it turns out that this complaint, that these allegations came forward were just, were completely frivolous and vexatious and essentially, exaggerated or fabricated, then you'll also want to consider the implications and the consequences for submitting a bad faith complaint of wrongdoing. Okay. As we touched on at the outset, we look at, how do we solve the problem in front of us, but how do we look at creating a healthy work environment? And one of the ways that a sexual harassment investigation can be useful to you is getting that insight into your workplace and, better understanding, are there systemic issues there that allowed this situation to develop and get to the level that it did. So you want to look at the micro issue that you're dealing with, the issue that the two parties have come forward with, but you also want to look more broadly at the workplace and just see if you're doing things in the right way. We had a client retain us a few months ago where someone was leaving the organization, but they made a complaint of harassment or wrongdoing on their way out the door. That person did not want to participate. The departing employee did not want to participate in the investigation, but this employer just felt it important to have us look into this anyway, and because they want to know, did these things occur, and is there anything here that we can do better? And that's an example of an employer just being really proactive and taking their obligations seriously. And not surprisingly, as it turns out, we found that this organization had a great culture, right? And you could see that reflected, almost in the decision that they made to go ahead with a proactive investigation. They just it meant that much to them to make sure that they knew who their leadership team was, that they are aware of how these, if there were these types of allegations that had come forward, they want to have confidence that their team knew how to deal with these in the appropriate way, and they were able to take the findings from our investigation to make some small tweaks to their systems. But overall, like I said, they had a strong culture, and that's reflected in their willingness to go about and self-reflect and analyze themselves. So with that, let me turn it over to questions. This is the Ask the Investigator webinar. So I invite you to please direct your questions to Leila direct it to everyone, using the chat function, and we'll do our best to answer them for you.
Just to let everybody know, so we've just been made aware that the chat function doesn't actually work. So if you do have any burning questions, please direct it to the Q&A function that should be at the bottom of your screens. But I have a question, Dorian, if to answer my questions. So what can you do if someone makes an allegation of sexual assault, sexual harassment, but does not want to take part in the investigation?
It's always very difficult, for the employer where they receive a serious complaint, but then they're told, by the way, I don't want you to do anything about this. And the easy thing is to defer to the employee and say, okay, I'll respect your wishes, and I understand that you want to remain confidential or you don't want to do anything at this time, and so we'll just sit on this and wait for until you're ready to take the necessary steps. The problem is that employers don't have that luxury, right? That's actually not a real choice that's available to them, in the sense that there's a consequence to doing that. When your obligation as the employer is, when you are presented with an allegation of misconduct, you have a duty, both in legislation and in the case law, to respond to those allegations and take them seriously and look into them. So once the employee comes forward, or once you become aware, however you become aware, that there is this alleged misconduct taking place, you have to look into it. And that may not be comfortable for the employee, and they may not want to participate, or they may want to put conditions on their participation. But at the end of the day, you do, as the employer, have a duty to conduct an investigation. You're going to have to get the information from the person who came forward, and if you can't get that information, you take what you have and you conduct an investigation to the best of your ability, based on the information that you have. So in the example that I gave, like I said, we had the employee who, in her exit interview, raised a whole bunch of serious allegations and then left and said, well, I don't want to participate. And so given that she is that she's no longer an employee, this organization could not compel her attendance, but they took the information that she presented and did the best investigation that they could in the circumstances. So where you have, and I think that raises an important point in terms of when you have someone who's still an employee, and they're saying that they don't want to participate, what leverage do you have as the employer? The reality is that the employee has a duty to cooperate with an employer's investigation, and there is case law out there that would support an employee can be dismissed for just cause if they do not cooperate with the employer's investigation. So you, as the employer, definitely have the leverage here to compel participation. You want to set up a process where folks understand their obligation, but at the same time are participating because they understand that you take these complaints seriously and that you want to create a healthy environment going forward, and their participation is necessary in doing that. So you want to create a safe environment, not a threatening environment, to conduct the investigation. But in terms of sitting back and just saying, we'll defer to what the employee wants to do, that's not a wise approach. Also from the perspective that in many cases, it's that same employee who then leaves the organization and may file a constructive dismissal lawsuit or file a human rights complaint and say in that lawsuit or that legal proceeding, I told my employer that this thing was going on and they didn't take steps to pursue it. So even though they're the ones that told you, hey, look, I'm going to tell you this thing and I don't want you to take any action, they're going to be the ones that will say, hey, I told you about it and you decided not to do anything about it. Then you, as the employer, are on the hook for damages. You cannot show up. It's just not a defense for you to show up at a human rights tribunal, in court, or at arbitration and say, well, the reason I acknowledge that this person told us about the misconduct, but the reason we didn't do anything is because she told us not to. That's not a defense. And like I said, you have to fall back on that legal obligation that you have to take these complaints seriously and look into them.
Thanks, Dorian. We have another question from an attendee. And the question is, how common is it for other employees to want to participate or give testimony, or are they typically reluctant?
I would say for the most part, folks prefer to be left alone, and they go to work to do their job, right? So when it comes to these, workplace investigations, this isn't an event that most employees, want to participate in. At the end of the day, like I said, the employer has an obligation to look into this. And if there are witnesses to event, if someone's saying, look, I was at this meeting and my manager berated me and it was extremely humiliating, and there were 10 other people there. Well, unless the manager admits to the complainant's version of events, you may have to speak to some of these folks. You may not have to meet with, likely you don't have to meet with all 10 people at the meeting, but you'll have to meet with a few of them to figure out what happened and what was said and how it was said. And so the nature of an investigation is that it's a fact finding. You're trying to gather as much or gather the evidence that you need to make a determination. And meeting with employees is a key part of that investigation process. And so while folks might not be willing, most employees understand that this is something that that they're obligated to do. And in my experience, I found employees and to be forthcoming in the information, even if they don't want to be there. When they're sitting across the table from me, they answer my questions and they share the information as to the best of their recollection. So I would say for the most part they're forthcoming. You also have employees who can't wait to come forward as well, right? Just because they've been experiencing some of the same things themselves, and so some employees are quick to come forward or eager to participate because they really want something done about a particular individual who may have made life difficult for them. So you get both experiences.
Okay, thank you for that. I have another question actually about just the fear of the process. So how can you actually lessen the fear that an employer is not going to do anything about it and is actually going to follow through with an investigation?
That's a fantastic question, and it kind of goes back to something that we talked about at the beginning, and that's culture, right? What are you doing as an employer to create a positive culture in your workplace, and a culture where people feel safe coming forward, right? So it's one thing to have the policies, but if no one ever speaks about the policies, if no one ever talks about the importance of positive behaviors, or reminds employees of here is the procedure if you are experiencing something that you find troubling. You may not even understand if this is a policy violation or not, but if you're experiencing problematic behavior, you have this safe route to make your complaint known, or to speak to someone in human resources, or to access a support person and get counseling. Right? There's many different layers to how you go about this, but one of the basic things that you have to do as an employer is to speak about the issue of wanting a safe and a positive work environment, and letting people know that you do take harassment concerns seriously, and that they should have confidence coming forward, because these are issues that the employer is keen to address. One of the trends that we've seen that started during the pandemic, and as more folks were working remotely, is managers communicating more frequently with staff, and that was just out of necessity. You're not seeing these people face to face. Everyone's working online, and so one of the aspects of your job is then communicating more frequently. So you want to, in your communications, raise the fact that, not so much talk about your policies, but just raise the fact that that we want to make sure everyone's doing okay. Maybe it's a check-in. Even from a mental health perspective, we want to make sure that folks are comfortable at work and are okay with how work is being assigned and how decisions are being made and how conflict, just normal conflict, is being resolved. And so, repeating these themes about being open and inviting feedback and letting people know that there's a safe process. Those are and repeating those themes in a consistent way. I think that goes a long way towards creating that safe culture that I mentioned. And then you also want to show that when you do actually get a complaint, that those complaints are investigated, right? Like you're actually taking steps, right? The investigation then becomes proof of the employer's commitment to maintaining a healthy workplace.
Thanks, Dorian. One last question I had, if anybody else doesn't have any more questions, is how important is timeliness when an investigation is taking place, with this type of investigation even?
When it comes to receiving a complaint and responding, and timeliness is important in no matter what the situation. And we've seen, so whether that's a situation of what I call like low-level harassment, somebody called me a name in the workplace, or if we're talking about sexual harassment, no matter what the concern, one of the issues that we've seen over and over again is that the complainants or employees, they get upset because they make a complaint, or they let it be known that they're going through something that they find troubling, and then there's silence from HR for a couple of months, and in that time something is actually being done. HR is trying to unpack that complaint and figure out if it should go to a third-party investigator, and they're consulting with their lawyers and senior management. Things are being done, but nobody takes the time to respond to the complainant to keep them informed as far as what is being done. And so the complainant and or the union is sitting there thinking, well, this concern was raised, nothing's being done, we're going to go off and file a human rights complaint, or we're going to go initiate other legal proceedings. And the thing gets a whole lot more complicated because of a lack of communication, or B, someone just taking a really long time to do their job. So timeliness is always important, because what you don't want is to have a small issue escalate into something like a human rights complaint, when it really could be dealt with in if it was responded to in a timely way, it could just be dealt with informally, or much in a much more efficient way than having to negotiate minutes of settlement in the context of a legal complaint, a legal proceeding being initiated. So timeliness is important, and can oftentimes result in a concern being dealt with effectively, as opposed to escalating into something more.
Thank you, Dorian, and thank you for today's webinar. Are those all the questions?
Are those all the questions that we have?
Yes, it doesn't seem we have any more questions, unless somebody does have any more questions to ask. But
yeah, we do have time. So if there's any more questions that come through, we'd be happy to unpack those for you. Also, you have our email and contact information there on the screen. So if you do think of a question after this presentation, please do contact us. We'd be happy to unpack that for you. But for now, as Leila mentioned, we want to thank you for your participation today. It's always a pleasure connecting with you in this forum, and we would invite you to next month's event on confidentiality, and can a witness record an investigation interview. That's going to take place on Thursday, June the 29th, and we'll provide you with a link for that event. And if you are enjoying these events, we would encourage you to spread the word and invite others so that they can benefit from the information that we are sharing. So thank you very much, everyone. Wish you all the best, and look forward to seeing you soon. Take care.